and probate is they're my passion. That's why I wanted to become a lawyer, and I love being able to help people, in hopefully in some of the best of times, and making sure that you're prepared for the worst, but also hoping for the best. That's what I like to tell clients, is we're planning for the worst, hoping for the best. So we will start. So I'm Kjirsten Anderson. I'm an associate here in estate planning at Stuart Law, and excited to kind of flagship, I guess, the estate planning division here. So we'll get started. I can figure out the process. Nope. There's a button. All right. So first, I always start with a disclaimer, especially with estate planning, is as of right now, I am nobody's lawyer who is attending right now, but I happily will become your lawyer if we can have a consultation. We can retain and figure out what your needs are. So, but as of right now, this is just purely for education and making sure that you understand estate planning, a probate process, and start thinking about that as you start making these decisions in your life. Okay. Sure. Thank you. Right. Go. Alrighty. So this is kind of what we'll go over today. So we'll talk about the importance of estate planning, the options that you have with estate planning, the probate process, which is the after death process typically, how to protect your assets, and we'll dabble a little bit into Medicaid qualifications and how to qualify for Medicaid. So why, and if anybody has questions, we'll save them more for the end, but just you can raise your hand or just type your questions in the chat, and we'll do that later. And we do have one person here. If you have any questions, right, just feel free to interrupt me. So all right, so we'll get started with why estate planning is so important. Estate planning is not for you, it's for who you leave behind, for the most part. Of course, there's things that you can do to ease your mind, but it gives you control over your assets, control over care for your children. It reduces, I'll need a slide. There we go. There you go. It can reduce some estate taxes and probate expenses, as well as authorize someone else to continue your business after you pass away or after you become incapacitated and are no longer able to do those things. So it's really a way to make sure that you're helping those you leave behind even after you've passed away. So you should be able to just hit that arrow, that little arrow button on there. Okay. Nope. That's okay. We'll figure it out. All right. And here's some of my favorite estate planning jokes, comics that I found. So the first one, the estate lawyer moms. That's me. I have a son, and I will say we do talk about estate planning. He's 2.5, so he totally comprehends everything. But the dragon ate the prince, but his trust lived happily ever after. We know that to be true. And then the second one with the turkeys. James did not leave a will, but he'll still be able to help determine which of you gets his inheritance. And there's a little wishbone right there. So what we like to do, we're a little bit more professional than that, but we like, I don't think a wishbone has effectively decided an estate, but anyway. So the big question that I think a lot of people have is, what's the big deal? Again, kind of going off what's important in estate planning. Well, what would happen if I don't get estate planning? What would happen to my estate? What would happen to my children? And so you can see this this graph on the left side of the PowerPoint here. And I won't go through it all, but you can see it's maybe a little bit complicated. It's asking, questions of, do you have any children? If not, here's how it goes. Here's who it goes to. If you don't have a surviving spouse, here's who it goes to. And so that's what we call intestate succession. So essentially dying without an estate plan, dying without a will or a trust. So your estate will go through probate, which is the legal process of distributing assets. And then the court decides on what happens to those assets based on current state law. So typically, a portion will go to your surviving spouse, and then then a portion would go to your children, and then if there's any left over, that would go to your spouse. So there's some back and forth with who gets what. If you don't have any children, but you do have a surviving spouse, a portion of that would go to them, as well as some would go to your parents if they're still living. But if you have no surviving spouse and just surviving children, it all goes to them, distributed evenly. So sometimes it's not the worst thing ever, but there's some people, obviously, who pass away without many family, or without heirs, is what we'll say. And that money could either go back to the state if there's no apparent heirs, or it could go to distant cousins, aunts, uncles, grandparents. It could go to people you don't want. If you have friends that you'd rather get some assets or take care of your estate, this is why intestate succession is maybe not the best for a lot of people, and it can kind of muddy up the probate process if you don't have an estate plan. And with that, the costs and time tend to go up if you don't have an estate plan. There's no direction on where your assets will go. It could cause fights or disputes among family, which we always like to avoid. And if you don't name your personal representative, which is required in Michigan, it's the person who essentially is the executor of your estate. If you've heard that term before, it's the person who runs your estate, essentially, with direction from the court. And they would be appointed by the court. And if you have an estate plan, you get to decide who that is. You get to choose someone you trust with your children, with your assets, and with estate planning too. If you have minor children or dependents who can't take care of themselves, you can appoint in your estate plan who you trust to take care of them after as well. So it's all about assets, and it's all about family. So that's what can happen if you don't get your estate plan done beforehand. All right, so we'll move on to the key estate planning documents. So what documents do you need to ensure that intestate succession doesn't happen? So we'll start off talking about the living documents, is what I call them. The things that only are effective while you're alive. So that are the powers of attorney. There's the medical and financial powers of attorney. Obviously, they're, by their name, you can tell what they are for. So we have the financial power of attorney, which is you can appoint someone to be your agent, essentially, where they would be able to have access to bank accounts or pay bills, pay mortgages, even continue on your business if you were to become incapacitated in whatever fashion or in whatever way. Without a financial power of attorney, the court could appoint a conservator over you, and that would be someone appointed by the state or by the court. Sometimes if you have that financial power of attorney, there's no need for a conservator. But if you don't have a power of attorney, then the court would appoint it. And essentially for guardianships and conservatorships, anybody can apply to be anybody's conservator, which sounds scary, but luckily the court and the judge are kind of to make sure that nobody untrustworthy becomes appointed. But that can be a little scary if you don't know the person who is handling your estate. And then we'll move on to the medical power of attorney, which in Michigan is called a patient advocate designation. And that's just who can make medical decisions for you, more physical decisions for you, if you become incapacitated. So if you have a surgery coming up and you want to prepare, like I said, prepare for the worst. If something goes wrong in that surgery and you don't wake up for a while, you'll have someone who you trust to make any medical decisions for you regarding your health and what will happen there up until the point of death. And again, with a guardian, like I said, with a conservator, that can be appointed by the court if you don't have anybody listed in a patient advocate designation. Next, I'll talk about the ladybird deed. This is kind of an in-betweener, a living document / an after-death document. So a ladybird deed we also call it an enhanced life estate. So it's like a beneficiary designation of real property. So you would sign a deed over to someone else that's only effective after you die. So you still record the deed just like normal. You have full control over your real property before you pass away. But as soon as you die, that person who you gave the property to would go to the records department, prove that you've passed away with a death certificate and another property transfer affidavit, which we can talk about later. And then the property would become theirs without having to go through the probate process. So that's why it's a little bit of a living and a after death document. So now I talk about the after death documents. So these are wills and trusts. A will is only effective after you pass away. You can change it all the way up until your death as long as you have the capacity to do so. But it will direct how certain assets will be transferred and distributed after your death. You can name guardians and conservators in your will for your minor children or any dependents that you have who need help after you've passed. And you can even, and one thing that that's important about wills is that they are made public after your death. They will be all the probate process is public information. So once your will and the probate process starts, any of those documents that are filed are then available to the public, which can be an issue for some people. But typically it's not, it's not the worst thing ever. If it's a fairly general will and things are going to go where people would expect, it's not that big of a deal for it to be public. The other thing, going into trust, you can create a will or a trust in your will. It's called a testamentary trust. That trust would, even though typically trusts remain private, because that trust is in your will, it is still public information, but that trust would survive your death as well. So trusts also are after death documents, but they're also kind of in that living document, after death document. They remain private for the most part, as long as it's not a testamentary trust that was in your will. And once you create a trust, so let me start over. So with the trust, there are three parties to the trust. There's the settlors, who are the creators of the trust, the trustees, who direct what happens with the assets in the trust. So to start out, the person who creates the trust is typically going to also be the trustee. And if it's a married couple, you can be co-trustees and work together and separately to distribute or add or take out benefit or assets from your trust. And then the third party is the beneficiary. So that's just who benefits from the trust. That can be children, it can be charities, grandchildren, even pets, or businesses. You can include business information in the trust. So a trust is kind of a living and after death document. It survives your death, unlike most of these other documents. Any questions about those? I know it's a lot of information about estate planning documents. Any questions about those?
No, not so far.
Sounds good. All right. So with all this talk about probate, let's talk about the dreaded probate process. So when is probate required? Probate is required when you have assets in your name alone with no beneficiary designations, no joint ownership. So I'll explain probate and non-probate assets next. So probate assets are individually held assets. There's no joint owner, no beneficiaries, and that will be included in your estate tax. So for me personally, I own my car personally. My husband's name is not on that car. Technically, that would be a probate asset, granted a low value one. And then for non-probate assets, those are jointly held assets or assets that have beneficiary designations. So typically married couples will own homes by what we call tenancies by the entireties. And that would be a joint ownership where you both own it, you have that survivorship. So it wouldn't be, as soon as one spouse passes, it automatically is in the surviving spouse's name only. And then beneficiary designations, of course, you can have life insurance policies, that have beneficiary designations, even bank accounts, even your cars can have beneficiary designations. And so typically if your goal is to avoid probate, adding those two things to your property is a great idea. So if you have a bank account that is solely in your name that has quite a bit of money in it, or any other kind of accounts, you can either add maybe a spouse as a joint as a joint owner, or you can add them as a payable on death or transfer on death so that it would avoid probate. I typically advise against adding children or any non-spouses or anybody you don't trust with money to those accounts, because then if they're a joint owner, they obviously have full access to the account and they can do whatever they want with the money without your consent, right? And so I typically would, unless there's someone you absolutely trust with that money, don't add anybody to a joint account unless it's a spouse or someone else that you absolutely trust. Also, with non-probate assets, the jointly held assets and the beneficiary designations will overrule a will and the intestate succession laws that we talked about before, no matter when the will was drafted. Like, for example, if I have a life insurance policy where my husband is the beneficiary, and if I drafted a will today saying I wanted Olivia here to get that life insurance policy, the beneficiary designation overrules that will. Even though I made the policy a couple years ago and I made the will today, the beneficiary designation overrules that will. There might be some battle in court, but typically that's what would happen. So we'll keep going with the probate process. So these are the general steps for the probate process. It can be a little bit complicated if you've never experienced it before. Even as an attorney, my first time going through it, I had to, get the step-by-step help to represent someone with that. So I was, grateful for mentors in that. So the general steps of the probate process are to first file a petition and several other documents. There's the petition, there's the inventory, which I'll talk about in just a minute. There's notices, there's testimony to identify the heirs. There's several documents that you need in order to open an estate. And with that is the appointment of the personal representative. So there's some other documents as well that you can file in the beginning that state who would like to be nominated or who has equal right to be the personal representative. And typically, first priority right to be a personal representative is a surviving spouse. Next, it goes to children, and every child, biological or adopted, not stepchildren, they have equal right to be the personal representative. So if you have multiple children, you should designate at least one of them, typically just one of them, to be your personal representative. And then the others would relinquish it. If you have to go through probate without a will, some of the children will have to relinquish that right to be your personal representative in favor of one child becoming the personal representative. And from the court, that personal representative will get what's called the authority, or they'll get authority from the court to be your personal representative, which just gives them access to do what they need to with your estate, with your assets, in order to close the probate process. So the next item on there is the inventory of assets. Yeah,
This would be if you didn't have a will or a trust, like if it went into probate.
Yes. So wills go into probate no matter what, even. Okay. But the appointment of the personal representative is required either way. Someone has to, be in charge of moving the assets and distributing. But with a will, you can appoint that person. You can say who you want. But if not, then there's other people who could have a say in being a personal representative. And if there's nobody who wants to be, then the court will typically appoint maybe like an attorney or like we call them guardian ad litem sometimes with other things. So essentially it's just a trusted person to act as personal representative just to get the estate closed.
Okay.
Yeah, so a personal representative is required if you go to the probate process with a will or without a will. So the inventory of assets is just another document that the court needs that lists all the assets that are in the deceased person's name only. So no jointly held property, no nothing with beneficiary designations, just things that are in your name alone. And there is a fee associated with that. There's a website where you can just, you can Google like inventory calculator Michigan, and you type in the full amount of the assets that you compiled for the inventory, and then it'll tell you how much it costs. It's usually a pretty low percentage. I think the most I've seen on a inventory fee was close to $200. I don't remember how big the estate was, but it's a relatively lower number, but it seems like a lot when you're already filing, the petition and filing fee and all these other things. But and then the next thing is another thing that costs some money, is a notice to creditors. So you have to, if you don't know of any creditors, or if you do, you have to publish notice either way. The notice to creditors has to be published in a legal publication for a certain amount of time. And that costs, it changes every year, but it's probably close to $150 or $200 now for that publication. And then it has to be in those papers for 4 months. Whether you have a will or not, it has to be in those papers, or at least it doesn't have to be in the paper for 4 months, but there has to be 4 months from the time it's in there until the estate can close. And with all these documents, you have to notify all the heirs when you're filing the petition, when you get appointed as personal representative, when you file the inventory. Everything has to go to the living heirs. So all the children or the living spouse, whoever is not the personal representative, essentially needs to be notified of everything that's going on in this estate, in case there's any issues, in case they know something that maybe the personal representative doesn't know, or something like that. And then in order to get to the closing part of the estate, you have to pay any estate taxes that are required, distribute the assets, and then file the closing documents. And so the entire probate process, according to Michigan law, has to last at least 5 months. It cannot ever be shorter than that. Whether you have a will or not, it's always 5 months. You have to have at least the 4 months for the creditors to come. And then you have to have, there's another month in there just for good measure, I think, and just to make sure that everything gets taken care of so people aren't necessarily really speeding through the process and missing things. So that's the general probate process. I'll get into a little bit more detail with some things. But any questions about probate process in general right now?
No, what's considered assets? Are they just all the financial stuff, or is it like real estate? It would be real estate also, but real property also?
Yep. Yeah. So any property that's held in your name, if you have a farm, or even if you have like a business that's in your name only, any assets from that business could potentially be part of your estate, unless it's in like an LLC, then that's a separate issue. We won't get into that today. But yeah, so anything that you own personally in your name, anything you have a deed to in your name alone, any bank accounts, annuities, life insurance policies, anything like that, that's, I guess, life insurance policy. Hopefully you have a beneficiary designation, but yeah, anything that's in your name alone that you own. And so this probate process, so what I'll talk about now is 2 different types of the probate process. So I'll start with the small estates. So if your estate is less than $50,000, which tends to happen with married couples, especially since they'll own most things together, they really don't have any assets in their name alone that will be probated, especially not that's over $50,000. Like typically most cars don't cost over that unless you've got a really nice one, and things like that. So the probate is not required whether or not you have a will, but hopefully you can still make sure you have one of those to make sure to make sure that that's being followed. But there are other ways to distribute that money and those assets, and that's some of the things I listed down there. So there's assignment of property and the transfer by affidavit. Those are 2 documents that you can have, that will essentially just show whoever maybe has money of your spouses or whoever passed away with less than $50,000, be like, I am entitled to this money, please give it to me. You can pass off that affidavit or assignment of property, and then you're good to go. This happened with my aunt and uncle recently. My aunt passed away, and there was a check that came from the state of Michigan for $500, and it only had her name on it, and he couldn't cash it. And so he just filled out the affidavit, took it to the bank, and they cashed it for him. He was all good to go. And so that's a way to kind of ease some things if the estate is less than $50,000. And you can use those documents to go collect money from an employer, Like I said before, you can have beneficiary designations on vehicles, or you can typically they're less than $50,000, so you can just go to the Secretary of State and get those transferred over into a different name. All of these places, the banks, the SOS, they'll have documents and things that they need from you too. And unfortunately, I can't give you a list of what they require because every bank is different. Every person you get up to at the Secretary of State is going to have different requirements, I feel like, for you. So sometimes you'll just have to go and figure it out yourself, unfortunately. But typically hopefully they'll be, kind in your situation. And then obviously collecting any other personal property, distributing that. If you have trinkets at home that you know that your spouse would have wanted to go to a certain child, you can always just give those away. And then we'll move on to the informal probate. So informal probate is the same general steps that I mentioned before, but it's not closely monitored by the court. There's also formal probate, which is just the opposite. It's closely monitored by the court. Every step is in front of a judge for the most part. You can do stuff away from the judge, but you have to have direct consent from the court and then direct consent from all the heirs, and making sure it's very monitored. It's a supervised probate process, so it's a little bit more complicated. I think typically those will happen when there's a lot of disputes or it's a bigger estate. But so far, actually, in my practice, I've not had a formal probate, but it's mostly just been informal, and that can be it's a lot simpler to do it that way if possible. All right, so we'll jump over to Medicaid planning for just a moment. So this is mostly just how you qualify for Medicaid. So Medicaid is a joint state and federal health insurance program for individuals with low income and who need medical care. So who qualifies? Adults over 65 or 65 and older, low income adults, pregnant women, and people with disabilities. And if you have the low income, there's that threshold for you. You have to make less than $20,800 for an individual, or $20,800 for an individual, $28,000 for a couple, $42,800 for a family of four. And you do have options with, if you have certain assets that are above the qualifier. There's not a ton of information about how many assets you can't have, but it's typically what's in your bank. If you have those amounts, then you automatically don't qualify. But you do have the option to spend down to qualify. So if you have a ton of really great assets, you're able to essentially distribute those in a specific way in order to qualify for Medicaid. So some of those assets to spend down. So some of the exempt property, I think I got this down. So exempt properties would be like your house, life insurance policies up to a certain amount, one car. If you own one car, that would be exempt. And then non-exempt properties would be cash, jewelry, more personal property type assets. So if you have a lot of those, you'd have to distribute those in order to qualify for Medicaid. And with Medicaid, of course, comes Medicaid estate recovery. So if once you pass away, and if you were on Medicaid and you pass away, Medicaid does have the option in certain cases to recover the benefits they gave to you from your estate after you pass away. So that's part of the reason for the notifying the creditors. They technically would come in as a creditor to get that paid back. If there are certain ways too, though, if your family is still relying on certain assets from your estate, you can file what's called a hardship waiver, where if you qualify, those assets would not be able to be taken by Medicaid from your estate. So hardship waiver, it's typically if your family relies on like your house or certain assets that you had before you passed away, they would have to file a document with Medicaid saying, if you take the assets, if you try to recover from my father's estate, even though he's on Medicaid, we are going to have significant hardship. You can't take this from us. And so if you file that document, then and you qualify, Medicaid will not recover from their estate, but typically they like to as best they can. Any questions about Medicaid?
No, other than tend to want to not be in that situation.
Right, yeah, you don't want to be in that situation, but sometimes, it's the only option for people. Health insurance is insanely expensive, and so sometimes it is an only option, which is unfortunate, but I mean, at least it's there, but there definitely are some big downsides to that as well. All right, so some of these I already talked about, just ways to protect your assets and ways to avoid probate. So these are the ways to avoid probate and to protect assets. So like I said before, jointly held property will avoid probate. Beneficiary designations will avoid probate. The transfer on death, the payable on death, those will avoid probate, as well as trusts. They will avoid probate as well, which is a big reason why people they like those trusts. They tend to be more expensive up front and a little bit more work, but it does save time and effort for people down the line. And then the other option is to minimize assets. There's certain tax benefits to minimizing assets. If you have a ton of money, there's gift tax laws where you can spend a certain amount on people throughout the year, and then that won't be accounted towards your taxes. You won't be taxed for giving such a large gift, and that changes every year. And so then the question is which to choose. It depends on your situation. Typically for married couples who trust each other, which hopefully all do, but you never know. I definitely recommend jointly held property. Beneficiary designations are always a good way to go, along with the transfer on death and payable on death. Typically trusts, again, it just depends on your situation, if it's a good fit for you. Sometimes it might take more time and effort than you want, and so a simpler will is all you'll need. But it just depends on your situation and your specific needs. I had a mentor for estate planning one time say that he loved estate planning because it was like puzzles. He had to make the puzzle fit for every single client that he had. It was a different problem for each person. But I mean, in a way, it's a great problem to have, to need estate planning to come do that. So we're always happy to help you with whatever you need. So then the big question is, when should I get my estate planning? And I always say as soon as possible, no matter your age, your situation, other than anybody under the age of 18. Get your estate plan as soon as you can, especially if you have minor children. An estate plan is such an important thing to do, at least to just, if nothing else, to make sure your children go where you want them to go to the person you trust most. And then, of course, once you have your estate plan, it's important to update it whenever you have any life changes, marriage, divorce, more children, you move, fluctuating assets, anything like that, especially state to state. Typically, there's different requirements. So Michigan has certain requirements that like Florida or Ohio don't have. And so typically, especially for wills specifically, you don't want to redo the entire will. You just want to add amendments to it. So it's not, the same expensive price every single time you'd come into me to talk about your estate planning or to change something. We would just add it's called a codicil, but it's essentially an amendment to your will. You can do that with trusts as well, as long as they're revocable, and you can change whenever you want. But if any situations happen, so. And so I'll finish with this final quote, just saying, with death, our financial responsibilities do not end, they just change. We like to talk about sometimes that we have stewardship over certain things. We're in charge of certain things. And just because we pass away doesn't mean that we're not still in charge of our children. We're still not in charge of taking care of them in any way that we can. So just making sure that you finish those financial and familial responsibilities once you pass away. I think that's a really important thing to make sure that you're doing for your children, to leave that legacy, to leave a positive note. And so I'll finish just by saying thank you to all of you who came in, and whether online or in person. And I'll open it up to any questions. I think we can see a chat here if we pop that up. But happy to answer any questions. But thank you so much for being a part of this momentous occasion, our first estate planning workshop. So thank you so much. No, not so far. Great, that is a-okay. Anything else?
Is there a benefit between like a will or a trust as far as the flexibility of it as assets change?
It depends. So if they're both fairly easy to adjust if needed. With a will, like I said, you probably want to come in and add an amendment potentially, especially if you like, or typically we try not to add like specific assets to a will. We have devices in Michigan where you can just write simple things out for personal property anyway. But if you have certain devices, like if you want, the farm to go to child A, and you want the house to go to child B, and that changes, it would be fairly simple to change that while you're alive. With a trust, same thing, as long as it's irrevocable. So there's irrevocable and revocable trusts. Irrevocable trusts, you have to have permission from just everybody, even the people who would be benefiting from that in the future. They'd have to give their consent to not get an asset or to get an asset, or to change that will or to change that trust. And with a revocable trust, you can pretty much change that whenever. You can add assets, you can take assets out. So
I guess I was thinking more if assets change, like if a house was in the will and you sold that house and bought a different house, then as far as you'd have to update either one, the trust or the will, correct?
Yeah, you'd have to update them and make sure it would be as simple, just like, we still want this house, it's just a different house going to this person now, or whatever. It's like this new house, same thing as before, it's just a new house.
Mm-hmm.
So just making sure that you have all the stuff documented in the will or the trust to make sure that anybody who's reading is like, okay, this house they don't own anymore, they bought this, they sold that and bought this one. So any documents that you would want in your packet, which I have our fancy new folders, we would, with your estate plan, we just put every document in here. You can add documents yourself. And so we would just add, if we have a trust, we just have the full trust in here and add any additions to that. But it's fairly simple to do those.
Okay.
Even with the ladybird deed, if you were to sell that house that you had a ladybird deed on before, that's just gone. Essentially, there's not really much you have to do for that. It's just that person no longer gets a house because you don't have any claim over it anymore. So yeah, it's fairly simple. Just be like, yep, I just moved, we have a new house. Be like, great, we'll just write it down. Here you go. Fairly simple.
Then do you do a separate will? I know for wills you do like a separate will for like myself and my wife. Like on a trust, would it be a separate trust for the two, or is it a joint trust?
You can do joint trusts for spouses, and so you would both be the settler, and you could both be co-trustees where you'd work together or separately. But yeah, we can do joint trusts as well. Yeah, you don't need a separate one, which is nice. Saves time and money.
Yeah.
Sure. Yep.
And then I guess my last question, like, if is there a difference, like if both people pass away at once, like, you're in an auto accident or whatever, and both spouses pass at the same time, is there a difference for that versus individual, or?
Not necessarily. The only thing would be that now, instead of one of you taking over the will or the trust, you would just have secondary trustees named, or even tertiary. Like you could have as many people as you wanted, or even companies will sometimes act as trustee. So they would just now then be the trustee, that secondary person. And for a will, kind of the same thing, just whoever was listed as personal representative. Typically spouses, will add each other as personal representatives, but again, you can have secondary or tertiary people listed on there. So just whoever's named next would then just take over. So it's relatively the same process. We're just kind of skipping the step of one surviving spouse being a part of it. It's a great question. Anything else from online or anywhere? Great. All right. Well, thanks so much for coming today.